without further ado, James, if you're ready to take the reins, I'll hand over to you and you can get going on transport.
But yeah, thank you for the introduction, Hayley. So I'm one of the solicitors in the practice. I've got the pleasure of delivering the last webinar in the series, which I'm going to talk all about transport. So just before we begin, the sort of slide that you may have seen on the other webinars, but for those joining for the first time, for example, this PowerPoint is more sort of a generic sort of run through of the law rather than specific legal advice to your case. So if you do have sort of specific questions or you need specific answers to certain questions, for example, please do get legal advice in terms of your individual case rather than relying on this presentation as a sole answer. So it's just a sort of little housekeeping warning. But the sort of areas that I'm sort of be covering is transport, of course, but just to sort of give you a sort of bit of context if you're sort of coming from this afresh, because the transport is, especially in relation to special educational needs and disability children, SEN children, transport is costing local authorities a lot of money. There's no sort of getting around from that, and you may have seen sort of news articles, for example, which points out that local authorities are spending more on SEN transport than they are actual SEN provision, for example. Now that is the case. It still is the case with some local authorities, for example. So therefore, as a sort of general rule, is what I find is that if there is a local authority spending money, then there's likely to be some difficulties in terms of how they're applying that for parents, and there's likely to be issues arising, which there certainly is for transport. So the sort of key areas that you need to sort of look out for transport is really what the law in relation to transport is for different age groups, and it does apply differently for different age groups, as we'll see. What is classed as suitable transport for your children and young people? How does transport look within EHC plans? How does transport impact on SEND tribunal appeals? So what impact does that have, particularly on Section I placement appeals, for example? And how to challenge if you get an adverse transport decision, which unfortunately you may well do. So looking at that to start with, it's what the sort of different age groups are and how that entitlement works. So there are 4 different age groups for purpose of transport. You've got non-compulsory school age, you've got compulsory school age, so 5 to 16-year-olds, you've got 16 to 19-year-olds, which will come under the sixth form age group, and then you've got 19 to 25. Sort of the adult learners and the EHC plans, of course, go up to 25. Unfortunately, for parents and young people, when looking at transport, the law does apply differently to each age group. So just looking at one age group isn't going to tell you the answer for another age group, for example. You have to look at each differently. And it does create a sort of unnecessarily complex sort of layer of legislation and law, unfortunately, which you do have to try and navigate through, which I'll go through and hopefully break down sort of clear enough for you so you can know exactly what the local authority should be doing moving forward. Now, the key legislation you'll see reference to this within the PowerPoint is the Education Act 1996. Now, I wouldn't recommend going and read that in any detail, for example, unless you really wanted some bedtime reading, for example. It's not a pleasant read in my view, but the statutory guidance for children of compulsory school age and statutory guidance for post-16 transport is a lot clearer in terms of what the transport duties are, and it's actually a lot more accessible for parents when looking at what the duties are. So I recommend having a look at that, and importantly, the local authorities do have to have regard to that and follow that when looking at their transport duties. So they're 2 pretty useful documents to have a look at in my view. So starting with what the legal entitlement is for the various age groups, we'll start with compulsory school age children. And that's very sort of deliberate because that is the sort of clearest duty you will find in relation to transport. The other age groups are slightly different and they're not as specific in terms of what the local authority should be doing. So Section 508B of the Education Act sets out the duty, and put sort of simply, local authorities must make, in the case of eligible children, suitable home school arrangements in order for the child to attend their relevant educational establishment, i.e. the school, and that must be provided free of charge. Now, that duty applies not only to children with SEN, but also children without SEN, for example. So as a sort of very broad generalisation for children with special educational needs and mobility problems, for example, the local authority must make available to them free transportation if they cannot reasonably be expected to walk to the school at which they are registered at, and there are no suitable arrangements to register them at school nearer to their home. That is what the law requires. And looking at that point, you need to sort of consider two sort of key areas on that point, which is eligible children, in my view, and what the sort of nearest suitable school is, to really sort of give the context to it. So when you're looking at who is eligible under that duty, you're looking at Schedule 35B of the Education Act, and the statutory guidance does provide commentary on it as well. But for children with special educational needs, disability or mobility problems, it provides that transport will be provided for children who cannot reasonably expect to walk to school because of their mobility problems or because of associated health and safety issues related to their special educational needs or disabilities. So if there is an impact from the SEN or disability which prevents a child from reasonably being expected to walk, they will fall under that duty. Now, for example, most children with EHC plans will fall under that duty, in my view. The sort of second one to look at there is also the statutory walking distance, which is pretty important, because that provides that free transport should be provided for all pupils of compulsory school age if their nearest suitable school is beyond 2 miles, if below the age of 8, or beyond 3 miles if aged between 8 and 16, for example. So looking at that, whilst if you come under the duty under sort of the SEN ground, the eligibility for the SEN, you don't need to consider a statutory walking distance. But if you are having difficulties with the local authority, for example, and they're pushing back and saying, well, your sort of needs don't sort of come under our eligibility criteria. Actually, if you look at the statutory walking distance, because unfortunately a lot of the times for children with SEN, the sort of nearest suitable school is not always going to be the local primary school, which is just down the road, or it's not going to be local secondary school, for example. It is often schools, specialist schools, which are perhaps 5 to 10 miles away, for example, which go above that statutory walking distance. So therefore, even taking away this sort of SEN ground there, you've still got the statutory walking distance, which means that the local authority would have to provide transport. So those are the two sort of key ones to look at when you're looking at the sort of eligibility of children there. And it's pretty clear there in those two that most children with SEN, for example, will probably come under that duty, in my view. There are two other points on there, which is the unsafe route eligibility and extended rights eligibility, but I won't go into any detail on this webinar, but there are sort of two other considerations there to make. So the next important sort of factor to look at there is what is the relevant educational establishment, and that is the sort of qualifying school or the place other than school where children receive education in Section 19 of the Education Act. So that's where your children can't attend school for sort of medical reasons or exclusion basis, for example, or other. But the sort of schools that can be provided for there are qualifying schools include mainstream and special schools, academies, free schools, PRUs, and importantly, any independent schools named in Section I of the EHC plan will also be a qualifying school. Now, the sort of key issue that tends to arise with parents and the local authority is what is actually the nearest suitable school. Because if it's not the nearest suitable school, the local authority may not provide transport under this duty, for example. And what the statutory guidance says there is that it's taken to mean the nearest qualifying school with places available, and the education must be appropriate to the age, ability, and aptitude of the child, and that must consider any SEN the child may have. So when you're looking at children and young people with the EHC plans, for example, if a school is named in Section I of the plan, then that is the nearest suitable school. The local authority can't make arrangements for any other to facilitate attendance at a nearest suitable school. But if you don't have an EHC plan, for example, if you're in the sort of process of obtaining an EHC plan and you've been refused and you're sort of going through the appeal process, then the sort of issue of what is the nearest suitable school is going to come into sort of play with local authority there, because the local authority are likely to say, well, this is the nearest suitable school, it's got places available and it can meet your child's needs, but you know full well that it can't, for example. So therefore that can be a point of challenge, which hopefully the EHC plan can take care of. But ultimately, if you don't have that EHC plan in place, you are going to have a dispute with the local authority. So you would need to sort of look at evidence that you could obtain that could possibly sort of dispute that in terms of whether or not it is actually suitable or not. But that sort of will come down to sort of facts of the case, of course, and whether or not that school has places available, for example, is a key point to look at, and whether or not that school says actually that they can meet needs would also be an important factor. But that's the sort of compulsory school age duty run through very quickly. As a quick sort of surmise on that, if your child or young person does have if the child does have special educational needs, for example, they can't reasonably be expected to walk and there is no nearest suitable school, then that duty will apply. Now that is different for different age groups. So for the non-compulsory school age group, for example, so 0 to 5-year-old children, the local authority are not under legal obligation to provide free transport for this age group. The same sort of duty that was set out previously doesn't apply for this age group, but the local authority sort of blanket refusing transport to this age group could be discriminatory and it could actually be unlawful. Then the local authority have actually got power to award the transport. So just because they don't have a legal duty to do so, they do have a discretionary power in section 508C of the Education Act, which they can make travel arrangements for any children for the purpose of facilitating the child's attendance at the relevant educational establishment, which when you're sort of looking at children of that age with quite significant, with special educational needs, for example, if they do have an EHC plan, for example, and the local authority have named a placement, specialist placement, which you need assistance in order to get your child to that school, then without the local authority providing that transport, would the EHC plan actually become unworkable? Because if they can't attend the school, can they actually receive the provision in the EHC plan that they need, for example? And if that is the case, I think you have very good grounds to sort of challenge the local authority if they won't provide you transport. But just having an EHC plan, it doesn't mean that you can't get it if you didn't have an EHC plan, for example. But again, you would have to be making applications to the local authority. If they're refusing that, you would then have to appeal that, for example, or look at other routes of challenge. So there's not a clear duty like there is with compulsory school age children. And then you move on to sixth form age children, which again doesn't repeat the compulsory school age duty. It is another different duty that you have to look at. Now, sixth form age children are young persons over compulsory school age, but under 19 years of age. But importantly, if your young person was actually attending a course they started when they were sixth form age, but they've gone over 19, if they're still on that course, then they will come under the sixth form age duty, for example. So what the law says on this is which is in section 509AA of the Education Act, which basically sets out the local authority have a duty each year to prepare and publish a transport policy statement specifying the arrangements for provision, transport, or otherwise that they consider necessary in order to make and facilitate the attendance of all persons of sixth form age receiving educational training. To put very sort of short on that point, basically local authority have to publish a transport policy statement, and that will set out the sort of eligibility criteria, and it is what they consider necessary. So there's no set criteria which has to be applied in each transport policy. So each transport policy that you will see, and you'll see them on your local authority's website. If you sort of Google sixth form transport policy, it will come up with your relevant local authority. But each policy will be different. The statutory guidance sets out a model policy, but it is applied differently in each local authority area. And the transport policy must include arrangements facilitating the attendance of disabled persons and persons with learning difficulties or disabilities. So if your post-16 sort of transport policy doesn't include any reference to helping disabled people and young people with special educational needs in their policy, for example, it would be completely unlawful. It would be very uncommon for a transport policy not to do that, but you wouldn't perhaps be too surprised with local authorities. But they will set out sort of their eligibility criteria in that transport policy, and that will be exactly what the sort of local authority will be applying when they consider necessary. The sort of quite interesting point on the sort of sixth form age duty is the fact that actually the Education Act doesn't sort of take into account that actually the compulsory school age has in effect risen now, because of course young people sort of between the ages of 16 to 18 are required to sort of stay in educational training under the Education and Skills Act. So the Education Act 1996 hasn't sort of incorporated that, and that's not a sort of requirement within the transport policies at this moment in time. But that being said, if you look at the sort of Education and Skills Act in a little bit of detail, there is relevant parts which would help as sort of young person in order to access transport. For example, section 68 of the Education and Skills Act says that local authority have a duty to encourage, enable and assist the participation of young people with SEN and disabilities to the age of for that age group to education and training, for example. And then paragraph 40 of the statutory guidance for participation of young people in education, which again local authority have to follow, is that the LA should ensure that young people are not prevented from participating because of the cost or the availability of transport to their educational training. So whilst there's not this sort of clear duty under the compulsory school age that applies here, there is still relevant legislation that local authority have to consider when they're drawing up these transport policies. And of course, they can't just simply exclude every child with every young person with SEN from transport, for example, because that's not obviously going to enable them to participate in education, which they are now required to do so, for example. So the key point there is what is necessary, of course, and looking at what is necessary for local authority, they must exercise this judiciously and in good faith. If the local authority don't exercise this discretion in good faith, this can be challenged, and it can be challenged by way of judicial review, for example, which I will come on to at sort of later point of the slides. But when looking at what the local authority considers arrangements to be necessary, the local authority have to have regard to certain things when drawing up this. So I won't read all of these, but for example, the sort of key points from there is what you can see to be necessary is that they have to consider the most vulnerable, socially excluded young people with SEN. The duty under section 15ZA of the Education Act applies. So that's looking at the age, aptitude and ability, any learning difficulties or disabilities, and the quality of education and training, for example. Distances and journey times will come into play also. So the statutory walking distance could be taken into account. And importantly, young people should be able to reach their educational training without incurring such stress, strain, or difficulty that they would be prevented from benefiting from the education provided. So it's got to be suitable as well. The cost of transport and alternative means of facilitating attendance will have to be incorporated and considered. So contributions can be asked for by local authority for this age group, and that is lawful. And you'll see a lot of transport policies, they'll set out exactly what their sort of contribution policy is, but that has to be appropriate, and that can't prevent the young person from accessing learning, for example. So if asking for a contribution from parents meant they simply couldn't afford it and they were unable to contribute to that transport, and the local authority said, because, well, you can't contribute, we're not going to provide that, that would be a point that could be challenged on an unlawful basis, in my view, because you can't prevent young people accessing learning just based on the fact that they can't afford the transport. And so you would look to challenge that. That's sort of what is necessary, but looking a bit more about what the sort of transport policies are capable of being challenged and have been challenged quite recently. And that went all the way up to a Court of Appeal case in Leicestershire County Council. Unfortunately, it was unsuccessful for the parents, but it did raise quite arguable grounds in terms of what the local authorities should be doing when they're drawing up their transport policies. There have been other transport policies which have been challenged. For example, it was Hampshire County Council which had to back down once they were legally challenged on one of the transport policies they were going to publish, for example. So there is mechanism to change these, to challenge the transport policies and take them through the court, for example, if you think the local authority have completely ignored the sort of legislation around those. But unfortunately, looking sort of more on a practical day-to-day basis, the transport policy has to be published the next academic year by the 31st of May. The transport needs of young people with SEN and disabilities must be reassessed when a young person moves from compulsory school into post-16. So that's really quite important there, because ultimately, if you're sort of wondering whether or not you are going to come under the eligibility criteria, the local authority should be making some form of assessment and considering the needs and whether or not that would come under the eligibility criteria and be necessary. So at that point, you need to sort of be asking the local authority, well, will they consider that? And I think when you're looking at that on a practical basis, the annual review and transition reviews, that will probably be coming up for some of you watching if you've got young people transferring from this age group, is that actually at that point, you should be looking at whether or not the sort of transport eligibility is going to apply for you and whether or not you're going to have any difficulties getting the transport. Because if you sort of just leave it to local authority and let them get on with it, for example, and actually you receive a decision notice in August saying, actually, no, you're not getting transport, you're not eligible under our criteria, then if you've got to challenge that, that doesn't leave a lot of time to challenge before September in the next academic year. So you really you sort of need to be making steps in order to sort of prepare for that as soon as possible. Now, of course, you'll sort of need to be looking at evidence to support your transport application and the eligibility, and looking at what that transport policy actually provides for, but importantly looking at what is necessary and how the local authority should be looking at necessary as well. So that's the sort of sixth form age duty in a sort of brief nutshell. And as you can see, the sort of key point there is necessary and what is in the transport policy statement itself. Now, looking for adult learners, sort of 19 to 25, that does differ again, but it's similar. But essentially put, the local authority must make arrangements for the provision of transport they consider necessary for adult learners. So again, it's sort of back to the necessary point, and the sort of same principles apply when deciding what is necessary as it did with the sixth form age children. When you're looking at what they must consider necessary, local authority have regard to the nature of the route or alternative routes that the adult could reasonably be expected to take. So again, that's set out in the legislation, and again, the sort of duties under Schedule 15 ZA is also applies. And the local authority will have to publish a transport policy statement for this age group. The local authority's transport arrangements for adult learners will generally be found in the post-16 transport policy, as is the case with statutory transport guidance that provides the sort of post-16 transport policy provides guidance on the adult learners as well, in case you want to read about that. But importantly, the statutory guidance sets out there that the sort of overall intention of the adult transport duty is to ensure that those with the most severe disabilities and no other means of transport are able to undertake further education and training after their 19th birthday to help them move towards more independent living. So when you're looking at sort of post-19 and there's still an educational need, for example, there's still an EHC plan in place and they're attending a sort of college provision, for example, then they may well be necessary to have transport in place, for example. If they can't access public transport, for example, then it may well be necessary that they need transport in place, and the local authority will have to provide them. And importantly, with this age group, actually, which differs to a sixth form age group, is that they can't expect contributions. It must be provided free of charge, and that is set out in the legislation. What I would also say is a sort of separate point but very related is if you are having difficulties with your local authority in relation to transport for sort of 19-year-olds, then actually you could look at the sort of Care Act. And Nicole covered the sort of Care Act in a lot of details when sort of young people are transferring over from the children's services to adult services. But importantly, you could look at whether or not sort of transport is required under Care Act requirements to sort of promote the sort of wellness of the young person there. So Care Act could come into play, and you could actually provide transport through that mechanism rather than relying on local authorities' transport policy, for example. I won't go into that in sort of any more detail. I would recommend looking at sort of Nicole's webinar and watching that in a little bit of detail to see how that might apply more specifically, for example. But that is the sort of adult learners summed up in a sort of brief detail. But again, as can be seen, it's not a specific duty as what compulsory school age children is. It is again more on the basis of what the local authority considers necessary, which is always a sort of little bit of danger in my view when you're asking local authority to look at things rationally and reasonably. Often they don't, and if you give them a bit more power to make these decisions, for example, then it's often not going to be in the interest of the young people trying to access the service, unfortunately. So it is not as clear, and unfortunately that is where a lot of issues arise with parents and young people not being granted that access, and local authorities seeking to sort of limit their duty as much as possible under that. So really you need to sort of, if you get an adverse decision in relation to this age group, you really do need to consider your options into challenging it, which I'll come on to at the end of the webinar. But looking at more specifically what the sort of travel arrangements might be that your local authority arranges for you if you are eligible for travel. This could be anything from a taxi, minibus, sort of taxi with an escort, mileage allowance, public transport even, or even personal budgets, for example. There are others, but those are sort of most sort of common. Looking at what sort of travel arrangements should be in place, there is a guidance document, which is called Homeschool Guidance for Pupils Requiring Special Arrangements. It is non-statutory guidance, unfortunately, so local authorities don't have to have regard to it, but that recommends risk assessments to be carried out and reviewed annually, which is quite important. So local authorities sit down and look at the health and safety issues of the transport, for example, look at exactly what is right for that young person or child and exactly what travel arrangements should be put in place. Now, when local authorities are considering what individual arrangements may be necessary, they should be looking at medical health needs. So would the sort of medical and health needs rule out a certain form of transport, for example, such as public transport? Is an escort required? So looking at that, with the sort of age of the child will need to be considered, gender, particular special educational needs, health and safety, the size of the vehicle, and length of journey should all be considered. So, for example, if you're looking at a 5-year-old who's just now eligible for transport under local authority, and they've got to travel 10 miles away in order to access the nearest suitable school, and that's a taxi service by themselves, it is very likely that an escort would be needed in that situation, for example, because that is the child may have quite considerable anxiety difficulties about it, and there may be other sort of associated needs, which means sitting in a taxi with an unknown person for that amount of time is going to be very difficult for that child. So that would be an example of an escort. And for example, another example would be perhaps if they're younger children, sort of 15-year-olds, and there's sort of 5 of them all in a taxi service, and they're all left in the back with their own devices, for example. If there's no escort in there, that you can imagine there can be some quite significant difficulties. So in that scenario, looking at the health and safety issues, an escort is probably needed. There are also mobility needs issues to be considered, such as wheelchair use and any anchorage equipment for the transport. The behaviour of other children in the transport will need to be considered, and actually arrangements in emergencies such as administrating medication. Now, I've been working with a parent quite recently on that point, actually, which in that specific example, specific scenario, the child actually had a diagnosis of epilepsy. The local authority were aware of that. They must have sort of been looking and reviewing their files, and they came across his care record, and actually it said in his care record quite clearly, and they had been provided with that he would need to be administered potentially with some epilepsy medication if a seizure were to occur, for example. The authority simply wrote to the parents, so we're withdrawing transport. We can't take children who require medication, for example. But what we do, so we're now withdrawing the transport. So when looking at that, the parent came to me and said, well, what can we do about that? And looking at that, we challenged that on a pre-action basis and said, you can't simply just withdraw the transport on those needs, for example, and you need to put in suitable arrangements. Now, with a sort of bit of back and forth with local authority in a couple of weeks' time, they rescinded their sort of position on withdrawing transport, and then they subsequently put in escorts who were trained to deliver medication and were appropriately trained in sort of emergency situations with the epilepsy, for example, knowing when to call the ambulance and what to do with the seizures, for example. But before that, they didn't have the escorts trained for that. And they'd actually sort of had a sort of policy within the local authority to say, we won't transport epileptic children. So therefore we had to challenge that, and they did back down. Now, another sort of a very contentious point with parents and local authorities is that local authorities often say you need to attend a pickup point, and the transport won't be from your home, the door, for example, then straight to the door at the school, for example. And what the sort of case law has said is, well, actually that can be lawful. So you can require the sort of children and young people to go to a pickup point, but actually it has to be suitable. So therefore we have to look at the individual facts. And again, I was working with a parent quite recently on this issue as well, and where the local authority were requiring the young person to walk to a pickup point in a very busy main street in a London borough, and it was about sort of 3/4 of a mile up the road. They had to walk to the pickup point and be collected by the minibus service. The parent wasn't able to walk, so the grandparent had to do that. And the EHC plan set out quite clearly that the young person had ASD, but they also associated with that had sort of quite severe anxiety difficulties and had no awareness of sort of any danger on roads, no public safety awareness, and no sort of stranger dangers. So that was all set out quite clearly in the EHC plan. But and then often there would be difficulties with the child trying to run off from the grandparent. But importantly, when they were sort of being dropped off at various sort of times of the pickup service, if the minibus was late or early, the child would actually be able to run off in the minibus service and across the busy sort of main road in London, for example, with lots of cars crossing. And of course, when you're looking at a health and safety basis, that is completely unsuitable to be expecting a child to be able to do that. And therefore, again, we challenged it on a sort of pre-action basis, and the local authorities soon backed down on that position. And then they put in place homeschool transport, so the minibus would actually come to the child's home address and pick him up from there, and then go on to the pickup point. So when you're looking at that, that has to be suitable for your child. So if you're thinking, actually, no, this pickup point really doesn't work for me, and there are legitimate grounds for saying this doesn't work, then you could effectively challenge the local authority on that basis to make sure that the arrangements are suitable. Which leads me on to the next slide, which is looking at what is suitable transport, and what does the case law say in relation to suitable transport, and what does the guidance say. And so the case law quite helpfully sets out that the local authority must make arrangements as it considers necessary for a child to reach their education without any undue stress, strain, or difficulties, such as prevent them from benefiting from the education the school had to offer, i.e. the transport must be therefore non-stressful. So statutory transport guidance mirrors that, but also provides some more details on that, which basically says transport arrangements should not require a child to make several changes in public transport and create an unreasonably long journey time. So if, for example, you've got to do 2 public transport routes, you've got to get a bus here and then a bus there, and then it's creating an unreasonable long journey time, that's not going to be suitable under the guidance, and sort of case law will support that as well. And also the public transport may just not be suitable for the child at all, going back to the original travel arrangement points. And again, sort of another point there is the length of the journey, which is often a sort of point of contention with local authority and parents. And what the sort of guidance says there is the maximum each way length of journey for a child of primary school age is to be 45 minutes, and for secondary school age is 75 minutes. And the guidance says this should be regarded as a maximum. So if your local authority is proposing transport arrangements, which means your child will be picked up and they're going to pick up various other children, and actually that transport route is then going to take 65 minutes for a primary school child, for example, you would be well in your rights to be able to argue that that's not suitable, especially if it does have a sort of a negative impact on the child, and sort of they're attending the educations, they're going to school and they're turning up completely dysregulated, for example, from being in the car journey that long. That would be an example of very unsuitable arrangements. And you would need to be looking at sort of more suitable arrangements to be put in place, such as direct transport route, which might reduce that length of journey. Now, that's not always the sort of case for children with SEN. Some of you may be watching and thinking, well, actually, my child can manage school sort of journeys, and actually the nearest suitable school is an hour away from their primary school, for example. So if you can sort of evidence that that would work for them, then of course that could be an argument to arrange the transport and have that placement named in the HC plan, for example. So that I think the sort of guidance does sort of acknowledge that journeys may be more complex, and the shorter journey may be desirable, but it may not be possible. And so therefore you can look to applying that. And importantly, that sort of suitability point does also apply for post-16 students. The sort of enduring stress or strain point applies within the case law, but also it provides that young person shouldn't have to make several changes on public transport if it would result in unreasonable long journey time. So that is across the board rather than just for children up school age. So therefore you need to sort of be looking at a sort of fact by fact basis for your individual case there as to what is actually suitable for your child. So if it is only the case that they can attend a maximum 20 minutes in the car, if not they are completely dysregulated and their anxiety difficulties just cause significant issues, for example, then that is what you would need to be sort of setting out to your local authority, and what sort of evidence you have to support that, because often local authorities won't necessarily want to hear that. So really important to look at that on an individual basis and how that applies for your child. Moving on to sort of transport within EHC plans and how that sort of works. Now, a very sort of common question we get asked is, can transport ever be special education provision? And the sort of previous and long-standing position was that transportation to and from school was neither a special educational need or needed special education provision to meet such a need. That was upheld in the sort of case of Staffordshire County Council, which we'll come on to in a little bit more detail later. But that was the sort of point that the tribunals operated on, for example, when looking at transport and what local authorities will operate on. But that sort of got slightly muddled when the SEND Code of Practice was issued, when the Children and Families Act came into place, because it said transport should be recorded in the HC plan only in exceptional circumstances if a child has particular transport needs. So that sort of looked at and sort of suggested that transport can go in the HC plans, which then in the London Borough of Haringey case, the tribunal said, well, actually, no, there is nothing actually out there which says we can't, which says that transport can't ever constitute a special educational need, and that special educational provision can't be awarded in the plan. So, and therefore, it sort of opened up the fact that it could go into a plan. And then you've got the case of the more recent case of the Birmingham City Council case, which confirms transport can be specified in the EHC plans where there is an educational training function. But the answer to that question will depend on the facts of the particular case. And it is very much up to the person bringing the appeal, for example, in the context of the EHC plan, the ECD tribunal, to make the case that it should go in there. And I think that has to come with a sort of a big warning as such, because the transport is in the EHC plan in exceptional circumstances. It's not going to be in every case, but there are sort of benefits of having the transport in the EHC plans, because ultimately if the transport provision is in there and it's specified in section F, if your local authority ever amends your EHC plan and takes that out, then of course you have the right of appeal to the SEN tribunal. But importantly, if it's special education provision in the plan, then you can look to enforce that if the local authority aren't providing that provision, because that would come under section 42 of the Children and Families Act. So therefore it is something to consider. I think it's a point that is sort of being tested in the tribunal as we go, because there's sort of no clarity since the Birmingham City Council case on what transport should look like in the EHC plan. But it is very fact specific, and you need to be looking at whether or not there is an educational training element. But again, it is in rare circumstances. And for example, if you've got a child of compulsory school age and they fall under that duty, I would find it incredibly unlikely that the tribunal would award transport in the EHC plan as well, for example. So it's going to be in very fact specific cases, and probably when you're sort of dealing with elder children and younger people when they're accessing sort of higher education institutions, in my view. And then we come on to sort of looking at section I of the EHC plan in a bit of detail, because this again is a common issue in dispute with local authorities and parents, because often the local authorities will seek to limit their transport duty by putting wording in the EHC plan. So for example, they may say, well, yes, you can have your placement, but actually we're not providing transport there. And even if you don't agree to that, we're going to put it in the plan, and that's going to be a lawful agreement, which is not the case. So looking at how local authorities should be applying this, and looking at when you're making requests for particular placements going to EHC plan under section 39 of the Children and Families Act, they should be looking at the way they should approach it. For example, if there's one school named in the EHC plan, it will be the nearest suitable school or college, and that includes independent schools. If the local authority states there is a nearest suitable school, but have not specified this within the plan, then the nearest suitable school will be the placement name in section I, because it's really on what section I of the plan says. If the local authority state there is a suitable school near to the home, it is in fact suitable, and there is a place available, the name and the parental choice of school when in comparison to this placement would be an efficient use of resources because of the transport, then the local authority could include wording into the plan for the parents to provide transport to and from that school, but that does have to be agreed by the parents. So sort of that could work in the favour of yourselves there, because if you're thinking, well, actually, we're going to provide the transport, well, that's a fairly reasonable request of local authority for us to do that, and that works for us as a family, then we would agree the wording to go into the plan, for example, then that's fine, and that might get you the plan named in section I of the EHC plan, which you want, for example. But often local authorities will seek to exert pressure on parents and get them to agree to that wording, when actually they can't do it and they don't want to provide the transport, and it's just not going to work for them as a family, for example. So when that does happen, the local authority seeks to put wording into the plan to that effect without your agreement, and that can be unlawful. You can challenge the place, you can challenge the plan on that basis. And I've done that through pre-action correspondence with local authority, who did that with naming a maintained special school out of borough. They named it in the plan, but they said the parents have agreed to provide transport, so therefore we won't provide transport. But when we were talking with the parent said, look, I never agreed to that. There's no record of doing it. I never agreed to it because it's never been workable by me, and I can't get my son to the educational placement name in section I. Therefore, that was challenged on a pre-action basis, and again, the local authority soon backed down on that and removed the wording from the plan and kept them at that school. That's a way of challenging it. I mean, if you do sort of enter into such an agreement with the local authority, I think you do need to consider how long-term this arrangement might be suitable for you, for example, because ultimately if you think, well, actually we'll do it for 6 months, and then if it doesn't work, we'll just ask the local authority to do it if you've got such an agreement. Well, actually the local authority could rightly turn around and say to you, no, you entered into this agreement with us. If you don't carry on with the transport, we've got a suitable school lined up, and it's this school, it's X school, and they've got places available, and they say they can meet the needs within the plan, for example. And therefore the local authority could look to sort of cease that placement of your choice there, and move the child back into sort of their choice of school. So it does come with a massive warning that it does have to be suitable for you long term before you enter into such agreements. And so therefore, transport is going to have an impact when you're looking at appeals to the SEN tribunal, because transport will have to be a factor that you have to consider, especially when you're doing Section 9 appeals. So when you're submitting an appeal on the basis of your EHC plan to the tribunal and you're saying you want this preferred placement, and that might be 10, 15 miles away, there is going to be a transport cost associated to local authority, for example, and that is going to be put up against the local authority's placement if they dispute your placement that you're looking for. So the cost of transport to and from the placement sort will need to be considered, as will the cost of the placement to and from the local authority's placement. And transport costs can be significant in cases, especially where there might be a need for individual transport with an escort, for example, and that may need to be considered. But the way, in sort of put simply, the tribunal will look at appeal placements is that they'll look at it even on a sort of needs and cost ground basis. So on a needs ground basis, they'll look at it on a sort of very simplified version. Is the school that you're putting forward suitable to meet the child's SEN? Is the local authority suitable? Now, if the local authority's placement isn't suitable, you don't need to worry about the cost of your placement, because the tribunal will have to name the suitable school. But if the tribunal decides, well, actually, we think both schools are suitable here, so we're going to have to look at the costs of the placements, then of course the transport cost is going to come into play there, and that might be the sort of tipping point between the local authority's placement and your placement. So you do have to really consider that. But looking at the sort of appropriateness of the placement, what the case law has said is actually that if the transport has to be taken into account, and if the local authority can't provide suitable transport to and from the school, then it can't be held to be a suitable school. So, for example, if your local authority are proposing a day placement school which is an hour and a half away from your home address, and your child cannot possibly participate in such a long journey, for example, then it wouldn't be a suitable placement. And that, of course, works for your chosen placement, because if it's a sort of equal distance away, then you might be facing arguments from local authority and tribunal, and we can't name that placement because it's too far away, and therefore it's unsuitable. So therefore, in that instance, you might have to consider sort of boarding or residential options at school, for example. But there's sort of moving on to the sort of cost point of the placements, and the tribunal will have to consider those costs, and the tribunal will have to sort of reach a balancing act in terms of what the transport costs are. So, for example, your local authority might say, well, we don't have any transport costs associated with our placement because there's existing routes there. We'll just add them onto one of that. It's not a problem. But actually, is there an additional cost to be added onto that route? Does that route actually exist, for example? Is that route sort of already sort of full? Is there actually any availability to put them in that taxi? Is there a need for an additional taxi to be created? And what is the cost of that? And just simply saying there's a shared transport route doesn't mean there's not a cost associated with that. And they have to split the sort of transport cost between the number of children in the taxi transport. So that, of course, works for your own placement as well, of course, because if you can evidence that actually my local authority is actually taking children to this placement already, there's an existing transport set up. The local authority aren't forthcoming with that information, but here's the information, and they can slot into that taxi. And of course, it's going to reduce your transport costs if your local authority is saying they're going to need individual transport with escort costs, where the costs are going to be quite significant, for example. So really, you have to look at it on a fact-by-fact basis as to what the transport is and how suitable it's going to be and what those costs are. And you need to sort of evidence that to the tribunal in order for the tribunal to make informed decisions on that. Now, your local authority, the tribunal often asks the local authority to come up with that information. If you think the local authority aren't going to come up with sort of an honest information or sort of full information about those, there are sort of ways in which you can go about obtaining that information, such as Freedom of Information Act requests. You could submit a TPA request. There may be some information in the TPA file as to what the local authority considers suitable, and therefore you can start to find out what the costings are and what existing transport routes actually exist, and then you can evidence that to the tribunal. And of course, you also need to consider what is suitable and what is the evidence to support what is suitable for your child and what suitable transport is going to be. Now, for example, you can look for educational psychologist advice as to what suitable transport is. Occupational therapist advice may come into play with sort of significant sensory difficulties, and any sort of medical advice would also can be included to advise on what is suitable. You can also look at psychiatric evidence, for example, for anxiety difficulties, and you can put that forward in terms of to the tribunal to sort of say, well, this is what suitable transport should look like, and that's going to have an impact on what the sort of local authority's transport costs are going to be, for example. And sort of you need to sort of be aware of that as to how that's going to impact on your appeal process. So something to be aware of when you are looking at appealing EHC plans, and importantly Section I, have a think about that and sort of how that applies to your individual case. But sort of parking the SEND tribunal for a second and looking at actually specific how to challenge on transport decisions you're getting from the local authority away from EHC plans. And there are different options available to you. So for example, if you've applied for transport and the local authority have said, no, we're not going to give you transport, you need to know how you're going to challenge that. And so you have different options to challenge. You've got the local authority appeal process, you've got complaints to the Secretary of State for Education, and you've got the local government ombudsman, for example, and you've also got judicial review proceedings to be considered. Now, what one applies and what one is going to be the best remedy there very much does depend on the urgency, in my view. So you need to consider as to what steps can be taken. As you'll see in a second, there are quite considerable timescales involved when looking at a local authority appeal process. So the parents, when you get an adverse decision, you have 20 working days to ask for a review of that decision. The local authority will then have to review that within 20 working days from receipt. The written notification will set out the nature of the decision reached, what factors were considered, the rationale, for example, and how you might go about escalating that complaint further. And then you will then have a right to sort of write into the local authority and escalate that further and request an independent appeal panel as formed, which the local authority will then have to do within 40 working days of receipt of your notification. The local authority independent appeal panel will take place. You can attend live and give verbal and written representations, and you can have someone there on your behalf, for example. The detailed written notification will then come after, and that should come within 5 working days. And that decision letter should set out that you have the right to escalate that to local government ombudsman. So that can be quite a lengthy process. Looking at sort of some examples that you might sort of make an appeal about if you did have to get a decision letter from the local authority. So what transport has been offered, sort of deemed eligibility, how far statutory walking distance is considered, is it actually statutory walking distance, are the local authority being misleading on this, and sort of the safety of the route, for example. There are issues with the local authority appeal process. I think Richard touched on it a lot in his webinar in terms of non-SEND tribunal remedies, which of course this comes under, and often they are over complex and they are set up in the local authority's officers' favour. They are lacking independence. There is the independent appeal panel doesn't have to be completely independent from the local authority. For example, it could be a local authority officer in a different team. They just couldn't be part of the transport team, for example. So that's not as independent as you think it might be, for example. And the sort of key point there for me is the sort of delay involved, because if you've got a decision midway through the year that transport is now going to be withdrawn for your child, for example, and you've got to go through this appeal process, in theory that can take up to 100 working days, worst case scenario, for example. So that is not really going to be an effective remedy there, because your child is going to miss out on a significant amount of education if you physically can't get them there because of the transport arrangement being withdrawn, for example. So therefore, you're going to have to consider sort of alternative routes, in my view. And sort of the alternative routes that exist, for example, from an ombudsman after you've been through the complaints policy. And again, that is lengthy, that takes 12 to 16 weeks. And Richard went through the local government ombudsman a bit of detail, so I'd watch his webinar in relation to some more details about that. There's also the Secretary of State for Education complaints. So you could be looking to make a Secretary of State for a complaint to the Secretary of State for Education. And in terms of sixth form age children, sixth form age group, the Secretary of State can actually direct the local authority to make transport arrangements or direct them to provide the financial assistance that is needed for the reasonable expenses there. So the Secretary of State could be a useful remedy there. But to submit a complaint to the Secretary of State, you will need to have given the local authority notice of the issues, and the local authority will have reasonable time to respond. Now, the Secretary of State are likely to come back and say you need to exhaust the complaint policy there in order for the notice to be valid. Now, that point is challengeable, and is likely to be the response you get from the Secretary of State. So therefore, the issue of time comes into play there again. And then importantly, there is no sort of set timescale for the Secretary of State to come back to your complaint there. So therefore, you're looking at a very sort of difficult process there, a lengthy process potentially, which in reality, some of these decisions need quite urgent attention because they are directly impacting on the child accessing education, for example, which comes on to the sort of final point of the webinar, which is judicial review, because this could very well be your sort of best mechanism in order to challenge the transport decision. Because as set out by the Upper Tribunal Judge, Staffordshire County Council, for example, sets out quite clearly a person adversely affected by a decision concerning provision of transport would have to seek a remedy by way of judicial review, for example. And Richard touched on judicial review in his webinar, so I'll just run through it briefly for those of you that haven't watched it, which is basically judicial review as a mechanism for the administrative court to review the lawfulness of a decision or action made by a public body. So therefore you could take the local authority to the High Court and say the transport decision they've reached is not lawful, and therefore the High Court could look at it. Now, the first step in which to do this is what is known as a pre-action protocol letter, which is what I've referred to the examples I've given with the parents that I've worked on with transport issues, for example. You send that off, a formal legal letter to the local authority's legal team, Director of Children's Services. Usually they'll have 14 days to respond, but that could be shortened. And then that would set it out, and the local authority would have to reply to you and set out their position. And often you can see the local authorities backing down at that point once their sort of local authority lawyers get involved and they're sort of looking at the duties that exist and how the local authority haven't applied that properly, for example. Now, importantly, you don't have to exhaust the local authority complaint policy or local government ombudsman in order to issue a pre-action protocol letter. The local authority will argue you do, and some High Court judges may take the view that you do, but there are arguable grounds not to have to do that, for example, when there's not an effective remedy. And I think the issue of time there is very important. And when you're dealing with a sort of unsuitable arrangement being put in place, which means that your child can't get to the school named in their plan, then that would be a point that could be challengeable by way of judicial review. So some examples there that you would look at sort of applying for judicial review, in my view, or looking at considering it. I'm not advising you to go out and issue judicial review proceedings by any means, because you need to be aware of the sort of costs involved, which Richard mentioned in his webinar. But the sort of examples where you can look to issue pre-action protocol letters, for example, is unsuitable arrangements, unlawfully withdrawing transport, challenges to transport policies, any unlawful agreements inserted into EHC plans, and panel decisions, for example, can be challenged by way of judicial review, and Secretary of State decisions can also be challenged by way of judicial review. So therefore, the judicial review mechanism, especially with the pre-action protocol stage, offers a relatively better route there, because you can look to be challenging that on the basis and getting a much more quicker decision. Now, if there was a clear sort of unlawful breach, we'd have the grounds to challenge it on a judicial review basis, and that is going to be a much more effective remedy than having to go through the local authority's complaint procedure. So therefore, it is something to consider. You do need to take legal advice from those to consider judicial review. You can't just sort of launch into it by yourselves. You do really need to sort of speak to a legal advisor about that. So, but it's important to have it in the back of your mind, because that, like I say, in a lot of cases, that can actually be the most effective remedy. So that is the sort of end of the webinar. I hope I've sort of kept it in time, but now it's time for some Q&As with Richard.
Thank you very much, James. That was great. We've got a couple of questions, and I'll start the first one off from David McCarthy, who was in very early before you got to this point, or sort of vaguely touched upon it, which is, how much regard would the tribunal have to the 45-minute primary and 75-minute secondary recommended maximum journey times for the government transport guidance in assessing a request by parents for a Section I independent school placement? Conscious this comes up in pretty much every London appeal that we have a conversation with the clients about, but what are your thoughts?
I mean, the tribunal will have to have consideration of it. Like I say, it's the tribunal will have to consider whether or not that guidance should be applied to the individual circumstance of case for that child, for example. So if that is completely unworkable to go over it, for example, then you've got evidence to support it. If the local authority, like I said, are putting forward that placement, then you've got evidence to say, no, that school shouldn't be named, for example. But actually, if you're seeking a placement which is a bit further away from the guidance, then I think you need to sort of be setting out clearly exactly how your child would be able to cope with that journey, giving the tribunal the option to sort of say, well, actually, in these circumstances, it would be appropriate to slightly go over that transport sort of guidance in terms of that journey time. And often the case when you're looking at sort of London placements, like Richard mentioned, for example, with the sort of traffic time and congestion, for example, they will sometimes go over that point. But I think you need to sort of evidence that if you need to work it in your favour, for example, and vice versa, if you need to say, actually, no, that's not going to be suitable. But it really does come down to sort of individual circumstance for your child and what is suitable in my view.
Lovely. We've got the second one from Jane Brooke Hughes. I'll get your view on this one, although it's a bit vague, which is, what if an independent school is named in Section I as parent preference? I'm conscious we run into this one quite a few times sometimes, and I suppose there's various situations about how this would work.
So do you mean if it's named in the HC plan on the basis of it being parental preference?
Yeah, I believe that's where the question is. It doesn't quite state it, but I think that's where it's going. So we'll answer from sort of that perspective.
Yeah, so if for example, the placement is named in Section I of the plan, and it says it's parental preference, so they're not going to provide the funding for transport, for example, that may well be the case, and you sort of need to appeal the plan to the SEND tribunal, in my view, to get that name without that wording put in place. But also, if they're sort of seeking to put the placement in Section I, but on the basis it's your preference, and therefore they're not going to provide transport, but they're happy with the child's return and they potentially fund the fees, for example, then again, unless that's with your agreement, that could be unlawful. But if that works for you, then of course that can be lawful agreement. But again, if they've done that and it's not lawful, you can challenge it on judicial review, but also you do have a right to appeal to your SEND tribunal. And so, for example, you can appeal to the tribunal and sort of achieve the funding for the placement and the transport by having it solely named in Section I as the suitable school that should be named, for example. So there is the sort of difficulties that can arise with the parental preference point there. I think it's important to know that you do have a right to challenge it. And if they are seeking to put that in there without agreement from yourselves, for example, you could look for a pre-action letter, in my view.
Got another question from anonymous attendee, and I'm conscious will be a split answer given the different ages in the question. Can transport be provided for 16 years ASD Centre in Mobility who have attended school out of borough 7.2 miles, and an 8-year-old whose school is 4.3 miles, ASD Centre in Mobility issues in the plan? Both have hidden disabilities. Can LA provide taxi or other means? The local authority are saying that the young person is able, but they struggle with unfamiliar routes and no safe walking distance. I suppose the question sums up with who has to apply, school or parent, as this is a separate process, the LA say.
Well, I think the sort of eligibility for the child there would apply, and would come under the duty, in my view. So local authority should really provide transport, especially if you can evidence that it's not in walking distance, for example, and they can't really be expected to do so. The sort of 16 point, again, that's sort of what is necessary for local authority. If they're arbitrary saying that actually no, your child needs to sort of get themselves there, or the college needs to provide that, well, actually that's not what the sort of law says. And it's the sort of local authority's duty there, so they need to consider what's necessary. And on the sort of facts of it, it sounds like they should be providing transport because of the sort of transport needs of your child there. So therefore, they should be applying that and should be providing transport. And so therefore, you should go for the transport application for the local authority. And again, if they're refusing that, then you've got sort of options to challenge that. And again, a sort of appeal process might be suitable, but again, sort of pre-action letter could exist. You could have grounds for a pre-action letter there, in my view, as well.
Brings me nicely on to the next question, because it's going to be a pre-action potentially judicial review point, and it's covered very nicely at the end of your presentation. I've got a question from Sue Rigby. Can I ask if the 16 plus transport policy state that you have to have a personal transport budget, and then after, can you dispute this and go for I think that's traditional transport? We're having many parents find this stressful as they know the personal travel budget will not be suitable, but the LA will not change this. How do we go around to help this to be changed and more suitable for parent carer, one less fight?
Well, I think that's an interesting question, because the sort of case mentioned on the PowerPoint there was the Leicestershire City Council case, which did actually look at personal budgets. And unfortunately, the sort of courts did take the approach that the sort of starting point in the policy could be that the sort of young person is awarded personal budgets, for example. But the personal budget has to be suitable and it has to be appropriate. So again, it comes down to sort of individual arrangements there. And if those sort of the starting point is a personal budget, but actually it doesn't work for any of the children, the young people to get to their educational establishments, and that's actually going to prevent them from accessing the education, then again you could look at challenging that by way of judicial review, and that's sort of what the sort of Leicestershire's Leicester's County Council case was about there, but it wasn't necessarily looking at the individual arrangements for the children. So therefore, you could look to challenge it on an individual basis there. And again, that is capable of way with pre-action letter or judicial review proceedings, for example.
Love it. I've got one from Marsha Ashman. Did miss the first 30 minutes of the presentation, which I think possibly covered some of this for the sort of transition into post-16. My 15-year-old is currently in a special school for medical needs. She's still on the roll in the mainstream, so has a dual placement. I applied for transport and she's currently gets a taxi with an escort. We're currently getting a final HCP and I'm naming her current mainstream post-16 in section I. Do I have to reapply for transport myself, or is it the LA's responsibility?
So the sort of LA have got a duty to reassess your transport eligibility, because of course, say it does sort of change there. But there's sort of, I wouldn't leave it down to local authorities. So I've been much more proactive on it and actually do it more sort of self there, because unfortunately, just because you've had transport under the compulsory school age duty doesn't mean it will apply and keep running just because you've got an EHC plan, for example. So a reapplication of transport policies for transport is probably going to be needed there. I wouldn't sort of sit on your hands and rely on the authority doing that. But as you'll see on the slides, there is a duty on the authority to reassess the transport needs, and therefore they should be looking at doing that. I think your sort of annual review process that sounds like you probably just had actually should have covered that point. So I would sort of be following up that with local authority as soon as possible, in my opinion.
And we've got the final question tonight from Jane Brooke Hughes. What if there are no suitable schools or places or prepared to offer a place within the maximum distance, and you are faced with considering boarding school? What is the situation regarding transport then? E.g., does it have to be the closest suitable school that offers boarding, which could be quite hard to determine?
Well, like I say, I think looking at sort of guidance there, you'd have to apply that on an individual basis. But if it's going to be the fact that it has to be a boarding school, then yes, it could well be, for example. And the local authority can provide transport to and from the boarding provision. So therefore, you would have to look at that. But again, there's sort of, if you were looking at it from a tribunal perspective, there are cases where the transport sort of guidance there has been extended, for example. So you could go above that if it meant actually parents didn't want their child support, for example. And I think if you are looking at you're in agreement that sort of boarding placement is needed because of the lack of suitable schools, then it would sort of be the nearest suitable boarding school in my view. But like I say, the local authority would have to provide transport from that boarding school, for example, on the weekends, or from term time, for example, if that's the boarding arrangement.
Just on that point, if you're in that situation, it normally does end up that there are very limited placements, so it does whittle your options down if you are in that kind of situation. But yeah, thank you very much for that, James. For everyone watching, thank you for if this is your first webinar, thank you for joining. If you've watched all of the webinars through November, thank you very much for sticking with us. And if you've missed any of them, they're all available on the YouTube channel, along with the experts, and also the January ones that we've previously done that cover a range of topics. As Hayley said at the beginning of this presentation, please engage with us on social media. At the end of the day, we try and put all of this content based on what people want in the same way that we do our newsletter. So interact with us, tell us what it is that you're looking for. At the end of the day, we're more than happy to support parents, and ultimately, if you need our services, then please do engage us. Our customer service team are incredibly friendly, and give them a call. Unfortunately, we don't have a legal aid franchise, so if that does fit you, and I'm conscious, it's about funding and how much people have for resources for legal cases, then places like Quorum, who do have a legal aid contract, are potentially going forward. But really, thank you very much for this. If you've missed any of them, please have a look at them on YouTube. And thank you very much for your time.
Yeah, thank you all for listening.